This
weigh in on.
conference will now be recorded.
Well, try that again. In the first meeting, we really elevated a few core issues of what is the scope of the recommendation, what exactly are we trying to recommend here, and how far should we get into substantive questions about protection of particular materials. And so in our last meeting, we seemed to coalesce around the basic point that here we're discussing process, not substance, though of course anybody who's taken civil procedure understands there's not always a perfect bright line between the two. But we're really trying to take for granted what is already protected, either pursuant to statutes or pursuant to the agency's own standards, and just try to frame up a process, a set of recommendations for process for how to go about protecting those materials that are entitled to protection. We focused on what we called confidential commercial information, which is a defined term now in the recommendations, as well as protected personal information. In general, again, we're talking about a pretty diverse set of sets of materials that we're calling protected materials, which again sort of begs the question about what's entitled to protection. But again, this is about process, not so much substance. And finally, sort of related to that last point, we need to be cognizant of the difference between things that are entitled to protection, that we sometimes refer to them as mandatory protection, primarily due to federal statutes that are detailed in Christopher's report. But then, of course, there's also what we call permissive protection, things that aren't necessarily entitled to protection, but the agencies, for their own variety of reasons, have determined that they're going to grant a measure of protection to these materials. So in this meeting, our goal is to walk through the numbered recommendations, beginning with what's now the first recommendation. Previously, I think was recommendation 12. Hopefully wrap up our discussion of that and then proceed through the remaining recommendations. We do have a couple of comments that were submitted in advance by Neil Eisner and Robert Stone, and I've marked those I've annotated the recommendations so that when we get to the right part of the recommendation, I'll be sure to bring in those comments, along with, of course, anything that arises during the course of the discussion. Just so you know, just so we're all on literally the same page, let's try to work off of the clean version that was circulated with comments. Needless to say, we can refer back to the red line as necessary, but let's just sort of take for granted that unless somebody says otherwise, we're talking about the clean version. Okay, with that, maybe now is a good time to call the roll. I forget, Todd, are you doing that?
Yes, I am. Sure. So, of course, Adam White is the acting committee chair. Then we have Emily Bremer. If I just say your name, you could just say here so we make sure that you're okay. Great. Dan Cohen, the government member from Department of Energy. We have Neil Eisner, senior fellow.
I'm present.
Great. Andrew Emery, special counsel.
Present.
Emily Hammond, public member.
I'm here.
Levon Schlichter, serving as an alternate for Hillary Mallory, government member from Department of Education.
Here.
Great. Randolph May, senior fellow.
Here.
Mitch Blade, serving as an alternate for Bao Nguyen, government member from the Office of the Controller of Currency.
Present.
Spencer Phillips, serving as an alternate for Rebecca Orban, liaison representative of the U.S. Coast Guard.
Present.
Fellow.
I don't think that came through. Did you just call Dick Pierce's name?
I did. I see Dick. Dick, your mic. Great. Bertrell Ross, public member.
Here.
Thank you. Lon Smith, senior fellow.
Here.
Kevin Stack, public member.
Here.
Robert Stone, government member from OSHA.
Here.
Tom Sussman, liaison representative from the ABA Admin Law and Regulatory Practice Section. Miriam Vincent, government member from NARA. Allison Zeev,
I'm here.
Susan Minson from OMB, Christopher Yu, project consultant,
Here.
Alex Zetzker from Department of Transportation,
Here.
Radha Vishnu Vajala, who will be serving as an alternate for Peter Constantine when Peter is out of the meeting.
Here.
RG O'Haron from DOJ,
I'm here.
Andrea Robinson Smith from DOJ,
Here.
Jamie Huang from DOJ, Virginia Huth from GSA, Michelle Walker from Department of Labor,
Here.
Davina Brown from Department of Labor.
Here.
Okay, David Pritzker, Special Counsel. And I believe that is all the people who have RSVP'd. I'm sure that I'm missing somebody. If I have not called your name, can you announce yourself?
Hey Todd, good morning. This is Peter Constantine from DOL.
Hi, Peter. Government member from DOL. Anybody
Good
else?
morning. Good morning. This is Melissa Rifkin calling from Pension Benefit Guarantee Corporation.
Great. Anyone else? Okay, Adam, I think that is the roll.
Great, thanks. And when I was recognizing the ACUS team that was here, I didn't see Sean on my staff. Sean, good morning. Also, I just want to especially recognize Bertrell Ross from dialing in from the West Coast. I'm always reminded that for us East Coasters, our morning Zoom sessions hit the West Coasters the hardest. So thanks, Bertrell, for joining us. Thanks, everybody, for joining us. Let's pick up with comment one, or sorry, recommendation one.
Adam, can I just interrupt you for a second?
Yeah, of course.
I think it would be worthwhile just to go over the basic rules in terms of voting and that sort of thing.
Yeah, thanks, Todd. I'm reaching for my script now. Okay, so we've already called the roll, obviously taken care of that. As with last time, ACUS members have full speaking privileges and are able to unmute themselves. But of course, in order to avoid background noise, if you're not speaking, please mute yourself. And then when you start speaking and forget to unmute yourself, we'll all chuckle at your misfortune while you go to unmute yourself. I'll call on you when it's your turn to speak, and I'll try to give everybody a chance to weigh in. Obviously, when we get pressed for time at the end, we might have to accelerate things. But I'll do the best I can. ACUS members, please, if you can, leave your webcam on when possible. Obviously, we know sometimes there are times you need to turn off the webcam. If my webcam goes off, it's because I'm ushering my dog out of the room. But in general, it's helpful to have your webcam on during the discussion. For members of the public, please use the chat feature to indicate if you'd like to speak, and I'll turn to you at the appropriate point in the meeting. The team will unmute you and then remute you when you're done speaking. For all participants, please use the chat feature only to indicate that you'd like to speak, or for committee members, the right time to vote. Let's avoid sidebar discussions and try to keep the conversation in the conversation for the benefit of everybody. Only members of the Rulemaking Committee, including government members and their designated alternates, public members, senior fellows, liaison representatives, special counsel, have a vote. Please do not vote unless you're a member of the committee. Todd and I have a list of committee members unless or in case you're unsure. In taking a vote from those who have voting privileges, generally we'll start informally just to get a sense of the room and see if there's a division requiring a more formal vote. Probably just do show of hands on camera. But if it gets more challenging than that, we'll have to call the roll with a vote. How'd I do, Todd? Is that all set? Did I forget anything?
I was trying to unmute. Yeah, that's all good. I would just want to emphasize one point: the webcams. I'm still showing a lot of people from the committee not showing themselves. So definitely, if you have a webcam, I understand not everyone does, but if you do, please enable it. Thank you.
Okay. All right, let's start with recommendation 1, which wasn't recommendation 1 last week or last time, but now it is. Again, moving this all up to the front so that this recommendation begins with the general principles of the benefit of the agencies informing the public of these issues so that the process begins with the public themselves taking proper steps and knowing which steps are available to them as they submit information in a rulemaking docket. And on page 5 of the clean draft, the draft with just comments, you'll see that ACUS staff has proposed moving some language from recommendations 1A to C, just moving it out of the recommendation itself into the preamble. I don't know if Matt, Sean, Todd, Reeve, anybody wants to explain that comment at all?
Yeah, Adam, I can offer a quick explanation, and Todd or Matt or others should feel free to chime in as well. So the thinking is basically that we look over this particular language. It seems like sort of the thrust is to give agencies a sense of the types of materials that are typically classified as being protected. But we're not sort of, as you had indicated, Adam, in your initial comments, we're not really in this recommendation trying to make a definitive statement as to, these types of materials are always protected and these are not. That's ultimately up to the agency to make that determination. So the idea would be to move this language up to the preamble so that it's clear that it's provided simply for explanatory purposes so that agencies have some sense of the types of things that we're talking about in this recommendation, the types of materials that often qualify as protected either as personal information or commercial information, but that we would not be taking a position in the recommendation itself as to what's in and what's out. So the idea is sort of, if that's the purpose of it, it fits better in the preamble as sort of explanatory background information as opposed to being in the actual recommendation proper.
Now, Neil Eisner has a comment that pertains to some of this information. We'll get to that in just a moment. But first, I'm just curious if there are any objections to the committee's, the staff's recommendation of just moving this to the preamble. Okay, seeing none, why don't we go ahead and mark that change. But in moving that to the preamble, I do want to flag Neil's comment. Maybe Neil could just maybe elaborate the point further if he'd like to, and we can discuss it briefly here, although we'll probably return to it when we discuss the preamble in the next meeting. Neil, I'll just read your comment and then you can jump in. Neil writes, I think it would be helpful for the committee to discuss how the tools that could identify privacy info for screening work. That is, would these tools simply identify all 9-digit numbers or also read the words surrounding the numbers to determine whether to identify it? Would they identify, quote, cancer or just, quote, I have cancer? Would they identify a misspelling such as I have cancor, etc.? Neil, if you want to describe that, and maybe Christopher might have some thoughts based on his research on how this works.
Yeah, one of the problems that was expressed a little bit in the first meeting and has always been a concern in the government is how much time it has, especially if the goal is to look at this stuff and make a decision before the comment is posted in the docket. And the agencies, when I was still in the government, the agencies were being pressed to get information get comments into the dockets as soon as possible. And the standards were, as I remember, Department of Transportation, something like a day and a half. And that's because other people want to see it. They want to start preparing for the discussions of things. They want to start following what's going on in the agency decision-making process. It is extremely difficult, when I was there at least, to get computers that could search in the ways that you wanted them to do it so you could rely on it. Agencies cannot review comments before the end of the comment period and get them in the docket within a day or two if they have to be responsible for reading every page of every submission to make sure something was picked up, and they wouldn't even necessarily know. If it's a social security number, but it doesn't say that, it's just the digits, how do you know it's not something else? And how do you know it's just not a mistake to put it in there, or it was intention to put it in there? And I think the problem is that there's sometimes a loss of understanding of how many comments come in, especially within the last few days. Agencies now like EPA and FCC can get not only hundreds of thousands, but sometimes well over millions of comments. Many of them are standard form, but they still might have something in them. They may have been based on a standard form document, the only difference being somebody adds a number that looks like a social security number, or adds something else that's confidential business information. And I don't think we can rely on the agencies. The tone has been softened. It is a lot better, but I think we need to understand the limitations of computers if they're there. If they can understand that when I say on a rulemaking involving something about cancer, I have cancer, will the computer pick that up? Will the computer pick it up if the word cancer is misspelled because of the context in which it's moving, it's being used? And I think if that's the case, the agency can review what the computer software program sends them to, but I'm not sure that computers can do this. And I thought if we're going to make that recommendation, we should understand the limitations, if there are some.
Now, Christopher, at pages 90 onward in your report, you do discuss some of the ways in which agencies deal with screening for protected materials. Do you want to maybe respond or to Neil's concerns?
So I think that Neil's concerns are well taken in the sense that, I'm particularly struck by his experience during the administration about the state of the art of computing at the time. And I think I would be, it's interesting, I would be careful not to lock in or presume at any particular time any particular technological state. That, I expect, is a moving target and always will be a moving target. And so I think that presuming that would, that can change actually for the better as well and should be dynamically so. Also his statement about the number of comments, he's absolutely right. For some agencies, they're being inundated by more than ever before. We did receive feedback from some agencies that they received relatively few comments just because of the nature of their subject matter. And that, again, reinforces to me the need to tailor the response to the individual agency. I will say that the computer tools have gotten much better at certain things. So, for example, he mentions about typos about canker. We all know from natural language processing on any search engine, it used to be one slight misspelling and anything you did with a computer caused it to crap out. We all know now they've become much more robust about certain things. It's not infinitely flexible. AI is very good at recognizing repetitive patterns. And so there are certain things that clearly it's going to be better suited for, such as a social security number in a classic format. The more you deviate from the format, it may struggle more. There are a number of examples of dates of birth, dates of marriage. It can't simply search for any date and being able to find associated information. It may not be able to pick that up as well. And I would guess what I would say is you wouldn't, is two ending comments. One is this need not be perfect in the sense that it's basically a tool to help flag things for review and possible revision by the commenter. But it's understanding that, I think, going back to a comment that was made the last time, the first line of defense is proper notice to people, description of their recourse, and any attempt to flag these through other means is simply an attempt to protect the people who are submitting comments for their benefit. Other thing is, the last comment I'll make is it's very imperative that agencies not all reinvent the wheel here. The hope is that there will be vendors that will provide this technology, which if you talk to computer science people is a pretty routine application of the current state of the art. But as you know, the actual real world implementations often trail the state of the art by quite some time. The hope is that regulations.gov or some appropriate actor will engage in a more systematic consideration that would probably benefit the entire government. So hopefully that's a great place we can leverage across agencies in a way that the administrative conference is ideally perfectly situated to facilitate.
Have we given any, this is Neil again, do you hear me?
Yeah, go ahead, Neil.
Have we given any thought, I know we've again said the agencies should do the best they can, not that they have to do something specific, but we've talked about many of these pieces of information inadvertently being submitted. Is it worth considering whether we have one, at least for the executive branch agencies, one docket agency set up, and if they put a form in there, or put a condition on submission of a document for the person to click the box, sort of like we click the box to say we've read the thousands of pages our new software program has put conditions on us or something like that, where you would go in and you click submit document, and the computer can come back and say, have you checked for inadvertent disclosure of any information such as, if so, here is a software, click on this and it can search your document for you. In other words, to put the burden back on the submitter, the agency can still do something and it can respond quickly to people who have questions and things like that. But putting that in there seems to say, you're submitting this, you're telling us all of it is okay with you. A third party may have problems with it, but everything's okay with you. And if you don't have the software, use the stuff that's in the docket, have it search your docket for you. I mean, document, not docket.
I was just going to say, and I realized I had muted myself, that some of the concerns that we're discussing right now, they overlap with the project that's noted in comment TR5, the parallel ACUS project on mass computer generated and fraudulent comments. And so there might be some overlap there. I think Neil's points are all well taken. I'd add, my concern that to the extent that there is mandatory protection duties and statutes, if there are any, we need to make sure that we don't propose that. I mean, I would suggest that we should avoid proposing anything that seems to sort of, really easily undermine those statutes. But again, I agree completely that the first line of protection for this is the submitter themselves. And so I would suggest for this, since we're moving this to the preamble and we're dedicating the next meeting to the preamble, that we take all these considerations in mind as we draft the new language that will take that part of recommendation 1 and move it into the preamble. And we return to the discussion next week. Is that okay, Neil?
Yeah, that would be fine. Let me ask one more question and I'll hand it off to others. Has anything been done with respect to for documents that have copyright protection? Commenter says, is my support for the argument I'm making against X or in favor of X is supported by a document by so-and-so, and then putting in pages and pages from a textbook that's got copyright protection.
Christopher, is that something you came across in your study of the agencies?
It clearly is. One of the congressional inquiries actually flagged this as a potential problem. After a close discussion with the administrative conference staff and a review of the document initiating this inquiry, it was agreed upon that would be out of scope for this particular recommendation and this report, and would probably be left for another potential administrative conference project. If I'm speaking correctly, Todd, if I'm mischaracterizing that, please, or if there's something I'm leaving something out, please feel free to add.
That's correct. That's exactly correct. Copyrighted materials are outside the scope of the project.
Great. All right. Thanks, Neil. Does anybody else have any comments on this general discussion? Okay. All right. Well, let's move.
I'm sorry. This is Andy Simons from EPA.
Sure, go ahead, Andy.
I mean, I guess I would echo what Neil was saying. I mean, we'll get into this, I think, later on in some of these other recommendations, but to the extent that this is suggesting a more affirmative duty on the agencies to do this scrub, given some of the context that Neil offered, I just think we should be careful about how, what we say about that and what's feasible for agencies to do, because I do think that we should maybe think about how to focus on the tools that allow submitters to submit the good comment, and as opposed to agencies having to scrub everything and have some sort of affirmative duty on this, or at least that ACUS recommends that agencies somehow this lies with them and people can kind of submit whatever they want, and we'll sort of police that on our end. I just don't know that that's feasible.
All right. Well, we'll return to this when the new language is inserted into the preamble. Thanks, everybody. Let's move to recommendation number 2. And this getting to the fact that we're now focusing on the submitters' need to be careful in what they submit. Recommendation 2 focuses on sort of notifying the public of these issues so they can go about their own work knowingly. There's one comment TR4. In the last conversation, I had suggested a recommendation encouraging agencies of the GSA to create some sort of checkbox or pop-up. And I know that that's spurred a comment from Robert Stone, which we'll turn to momentarily. I just want to say I'm sure I was sort of spitballing there. I don't want to presume any sort of particular technology or capability on the part of agencies. I was putting it out there as food for thought, as one way to go about informing members, informing the public of these issues. Let's go to comment TR5. This is the aforementioned parallel project on mass comments and so on. And then we'll turn to Robert Stone's comment. Todd, can we start with you again on this? You point to the fact that we teed up an issue of the weight that agencies give to anonymous comments and notifying the public of that so that they can sort of know what they're getting into if they choose to submit information anonymously. Can you just summarize the comment and we'll return to the conversation?
Sure. So the comment points out that there is another ACUS project currently underway looking at the phenomenon of mass computer-generated and fraudulent comments. As part of that project, there is going to be an analysis of anonymous comments, the point of which is that whether fraudulent comments, computer-generated mass or fraudulent comments is a problem depends on whether or not the identity of the commenter matters. So the project is going to be looking at anonymous comments, and we just wanted the committee to be aware of the existence of that project and the extent to which it's going to be looking at anonymous comments.
And Robert Stone submitted a comment. It's 2 paragraphs, so I won't read it verbatim. But Robert, although your comment is focused on these disclosure points as they are reiterated at recommendations 3 or 4, it really all sort of begins with I think it's all sort of premised upon recommendation 2. And so I wanted to introduce you into the conversation, get your general thoughts on this and your sense of recommendation 2, if you have any comments before we move on. So I want to make sure to do justice to your comments as a whole.
I really don't. I was really focused more broadly on making sure that individuals who want to respond aren't burdened by having to read through a mass amount of information that may not pertain to them. So there might be some flexibility to allow people who want to respond or who need the information to access it, but everyone doesn't have to read pages of material that isn't relevant to them. So in relation to 2, I don't really have a specific comment on this material.
Okay, well, thanks, Robert. We'll keep your general concerns in mind throughout the discussion of recommendations 2, 3, and 4. So I just want to make sure to bring them in right away. Well, let's jump right into. Oh, go. I see it.
Can I interject on?
Yeah,
this
Andy.
is Andy Simons from EPA. Before we move away from 2, I mean, I'm not sure what the purpose is of C with relating to the overall to reduce the risk of agencies will inadvertently disclose protected material in connection with rulemaking, and then we do these things. The weight given to anonymous comments just doesn't fit here. The other thing is it's fairly pejorative to say like the weight, if any, to suggest that that the agency might give no weight to a comment. I think it's a complicated issue, actually. I think, as you alluded to, who whether it's anonymous or not is more related to the content and various different things. So to frame it here just in terms of whether it's anonymous or not is also, I think, fraught with perhaps misleading people or suggesting that is more determinative than it is. So I would suggest that it's actually misplaced here and should be struck from this this list, because it's primarily it's not relevant to reducing the risk that we will inadvertently disclose protected material.
Well, just to be clear here, I don't want to race past recommendation 2. That's what I want us to discuss now is each of these sub recommendations. For what it's worth, I'll let the ACUS team weigh in on where that recommendation originally came from. But for what it's worth, I actually do think it's somewhat relevant to the subject matter at hand. If to the extent that agencies do accord more or less weight to anonymous comments, and maybe Christopher or others have thoughts on that, to the extent that we're trying to apprise the public and of both their rights and their duty to check their own material and decide the form in which they want to present it, whether they want to anonymize it all. If there are any consequences that flow within the regulatory process from choosing anonymous submission in order to protect privacy versus non-anonymous submission, I, for one, think it's worthwhile at least considering whether the public should be apprised of that before they make their choice. I just flag that. I don't have any hard views on it. And I would be perfectly fine with our committee eliminating it. I just want to make sure we discuss it. Todd?
Adam, Peter Constantine, I think, has a question or a comment on this point.
Go ahead, Peter.
Thanks. I did want to follow up. I agree. I do have some concerns about perhaps the unintended language of C. I think, and again, perhaps my DOL OSHA colleagues would chime in, but I think for DOL, we tend to give the same amount of weight to an anonymous comment as others. There may be on an individual basis a question. And so I'm just a little concerned that we are putting out here that every time there's an anonymous comment, moving from litigation to rulemaking here, my concern would just be the public's going to assume perhaps that anonymous comments are going to get less weight. I think the reality is agencies are likely to deal with unique situations on a case-by-case basis. So I'm just a little worried about the breadth of the language here. So I'm not saying get rid of it. I'm just wondering if we could revise a little bit. But again, I share the concerns of the other commentator on including this language. Thank you.
Peter, maybe, or go ahead, Christopher.
So I hear 2 concerns which I think can be resolved. I think the comment made by earlier, there's a legitimate, came up at the end of the conversation of our last meeting, and it was a little bit rushed about if any was unnecessarily pejorative, and actually even focusing on weight. There may be other implications about submitting anonymously beyond weight. There also is an aspect of this which applies to the commercial, confidential commercial information as well, which plays out a little bit differently. And I threw out the very end of last meeting try to make more. I am also sensitive at the same time to Adam's point about letting people know what the implications are. So I suggested a more neutral possible solution of inform members of the public what are the implications of submitting anonymously, without suggesting that they're going to weight or to anything. And as I read this now, I might even drop this down, submitting anonymously or requesting protected status for confidential commercial information, both, just so people understand what that is. And that way it may address some of the concerns about the pejorative quality of certain parts of this language and focusing on certain aspects, yet still support the disclosure ideas that Adam is, I think, correctly suggesting are important.
That seems like a good middle of the road. Yeah. I'm sorry, I didn't mean to cut it back. Go ahead.
I was just going to say, I was going to suggest even something like rearranging the sentence to say, if an agency accords different treatment or weight to anonymously submitted comments, then it should notify the public accordingly. But I think Christopher's approach is better. Does anybody else have any thoughts on this? I now have my chat window open, so I'll see if when people are raising their hands in the chat. Okay, I guess I'll just ask then, does anybody object to?
This is Levon Schlichter at Education.
Go ahead, Levon. Go ahead, Levon.
Yeah, sorry, I think my connection is poor. Yeah, can you hear me?
We can hear you.
All right, my connection is not very good, so I'm not sure. It seems like there's a delay, but just 2 quick points. The first is it relates to B and C of 2, and that's that not all agencies allow anonymous comments, or at least they have the ability to not allow anonymous comments in the future.
Levon, I think you're
that we should account for that with the language.
Levon,
so if the recommendation were to start out with,
you're dropping in and out, Levon. Maybe if you type your comment into the chat, we'll return to it. Sorry about that. Before Levon jumped in, I was going to say, if people don't object, we could direct the ACUS team to rephrase the recommendation 2C in accordance with Christopher's suggestion. But I see Robert Stone has a comment on this. So Robert?
Yes, my suggestion was to rephrase it to say inform members of the public what treatment the agency accords comments that are submitted anonymously. It's a more generic, I think, phrase. It's pretty neutral, but it at least allows consideration of special treatment of anonymous comments. That was it.
Okay. Anybody else have any suggestions on this?
Adam, if I could just summarize Levon sent me a note indicating what he was trying to say. So the point he was making is that not every agency allows anonymous comments. So the wording of B and C, so the wording of B would be problematic if an agency doesn't allow anonymous comments because B presumes that all agencies do allow anonymous comments. I think that's the point he was trying to make.
Okay. Well, what about just changing it to instruct members of the public whether they can submit comments anonymously? And then as to 2C, Robert's suggestion a moment ago, Robert, could you state that one more time? You're muted, Robert.
Inform members of the public what treatment the agency accords comments that are submitted anonymously.
Yeah, so the use of the word treatment avoids weight, which might be, no pun intended, fraught with implications we want to avoid.
Right.
This is Neil Eisner. Can I add something?
Please go ahead, Neil.
I have 2 concerns with the way we're addressing anonymity. Number 1, what if they say this is John Jones or Jill Jones? How do you know they're anonymous or they're not anonymous? More importantly, we're talking about we're getting away from weight, but we're implying that there's something that the agency doesn't want if they don't get your name. We're leaving out probably the most important thing. If you don't give us your name and your address in the government, then the government can't call you back to clarify something in what otherwise might be a very, very good idea. They may not realize they can't consider it because they need more information and they have no way to find you. So I think it's a complex question that needs to be addressed more carefully.
Adam, can I just jump in here? I think it would be, I don't know if Reeve has any thoughts on this. It strikes me that, especially after, I think Neil's comment makes the point well. It strikes me that we're really treading into the area of the other project.
Okay.
I don't know, Reeve, do you have any thoughts on that? I'll withdraw the comment if you disagree with me.
No, I agree, Matt. I mean, I think we'll give it a much fuller treatment, you know, in context of that project. I should note also Emily Hammond, who's also on the call, is another consultant on that project. But I think from my perspective, you know, anonymity is going to be sort of one of the fundamental questions we address, because it sort of goes to whether or not mass computer generated and fraudulent comments are an issue. The identity of the commenter is sort of one of the threshold questions there. So I think we'll give it much fuller treatment in the context of that report and probably ultimately that recommendation. So, you know, for what it's worth, I think that I tend to agree that sort of to give it full treatment in the context of this recommendation might be challenging, and we'll have a fuller record in connection with that subsequent project.
Okay, before we get to Spencer Phillips's comment, I just want to ask Christopher, if we were to just eliminate recommendations 2, B, and C altogether and sidestep the anonymity issue, do you think anything would be lost? Is that sort of creating any problems elsewhere in these issues?
I think that the committee should feel free to go either way in terms of this. I think that the spirit of this is notice of available procedures, and my natural instinct would be to include a placeholder, but try to be agnostic as to its content, to underscore that whatever the product of that consideration is should be carried through into the notice given to public commenters. If the other recommendation is going to include procedural recommendations as well, it becomes less important that the placeholder argument happen here. And so it's up to sort of the administrative conference and its members how they want to organize it. It's just a question to me of substantively, whatever the product this is, that there be an underscore, that people know what the implications are going to be. This is the procedure one. My inclination would be to leave a placeholder here just to mark the idea that whatever that other project comes up with, that it be disclosed. But if the administrative conference believes that's better handled than that other recommendation completely, both substantively and procedurally, that's fine.
Is this, I'll ask the ACUS team, is this something that we could allude to in the preamble to sort of flag the issue there, but not get into it with a specific recommendation? It's kind of hard to have a placeholder for recommendation because the placeholder isn't really recommending anything, right? So maybe this is something worth alluding to earlier in the preamble, but leave out of the recommendation.
The only, I'm curious to hear what Reeve said. The only objection I think you're going to hear from that, to that from some members, is that you're going to get a recommendation that's not kind of current when someone's reading it 5 years down the road. Reeve, is that a concern that is sometimes raised?
Yes, I think that's exactly right. And I think that would be the drawback to doing something like that. I think it probably will raise that concern down the road.
What about just a general statement in the preamble that, you know, anonymity, the questions of anonymity and pseudonymity, you know, raise other concerns and complications? And I mean, I'm just spitballing here, but
I think
is there a way we can refer to it generally without referring to the ACUS project?
I think that's perfectly fine. What do you think, Reeve?
Yeah, I agree. I think that's a good way of handling it, to sort of flag the issue, but, you know, yeah, not refer to something that's, you know, potentially in flux.
All right. Well, before I'll suggest in a moment that we just go that route with the preamble. But before I do, Spencer, you wanted to jump in. Do you still have a comment? Spencer Phillips, you might be muted still. There you go. Sorry, I muted you when you tried to unmute yourself.
Hear me
now? Go ahead, Spencer. Yep.
Okay. One thing I wanted to bring up was that with regard to like when commenters provide either their name or their information, if all they provide is their name and they say, I'm so-and-so from the affected industry, it's hard for us to verify who that is. So it's hard for us to put much weight on who they are when, if they don't provide enough information, we can't really know if that's just a member of the public or a member of an affected industry. So I thought it might be useful to, if we're going to inform the public that their comment, if submitted anonymously, might not be given as much weight, it might be worth including some mirrored language that says, if you provide information that verifies your identity as somebody who's, a part of an affected industry or something like that, then the agency can give you more weight. Thought that might be useful.
Okay. All right. Well, with all of that in mind, would anybody object if we move the substance of comments 2, B, and C out, and just note in the preamble at the appropriate place that there is the separate issue of anonymity or pseudonymity? Okay. All right. Well, let's do that then, Todd, if you can make a note to that effect. And let's look at the remainder of recommendation 2. There's 2A, this general statement of informing members of the public that all comments submitted are subject to public disclosure. And then 2D through I. Does anybody have any comments on the remainder of 2? I have one question for Christopher, and this gets back to this issue that came up in the first meeting about mandatory versus permissive protection. Is there a risk that 2A stated, in general terms, that all comments submitted are subject to public disclosure? Does that run afoul of anything like the Privacy Act?
So it may be worth putting a caveat there. It's one of the conversations that came up and was raised by in the previous meeting. The fact FOIA under Supreme Court law, FOIA exemptions are discretionary, but the way that FOIA works in here is it's not directly applicable to rulemaking, but it comes in through the back door, through the Privacy Act and the other statutes that actually make the scope of the Privacy Act protections depend on FOIA. And that aspect seems to be mandatory. And so there are some things that have to be disclosed and there are some things that have to be withheld, and that the statutory context of folding in the scope of the disclosure seems to actually carry the force of law. So what I think the issue you flagged, Adam, is an important one. Inform members of the public that all comments are subject to public disclosure, but I'm not coming up with the right words, but subject to law, but subject to other legal requirements. The default is disclosure. There are exceptions to that, and understanding that all that applies, subject to public disclosure, subject to other legal restrictions. I don't remember. I don't have the exact words in my mind, but putting notation there that right, the duty to disclose is by no means absolute, and that there are legal requirements that do require agencies to withhold information under certain circumstances.
What would people think if we substituted for this language along these lines? Inform members of the public that comments are generally subject to public disclosure, except where limited by law or regulation. There's probably a better way to put that, but that's generally, I think, what Christopher's getting at. I mean, I guess I want to make sure that last clause makes clear that we're talking about the disclosure, not the informing the members of this. Generally are subject to public disclosure unless except where disclosure is limited by law or regulation.
Adam, might it be easier just to say where disclosure is limited by law?
I'd be fine with that. Anybody else have comments on this? Okay. I see a comment came in the chat window from Allison. Allison asked whether we need a footnote regarding anonymity And Dick Pierce actually earlier in the discussion had raised the same point in the chat window. My thought was that we were reserving the anonymity discussion to the preamble now. I'd suggest we just wait and see what the ACUS team drafts in the preamble and return to that in next week's discussion.
Can I just clarify quickly?
Yeah, please do.
So, my comment was not where it should be, but why we were mentioning anonymity at all, because the topic of treatment of protected materials seemed to me that doesn't include anonymity, because if you file something anonymously, it's different from protected. It's just anonymous. That's all.
No, the point's well taken. Thank you. Does anybody have any other comments on other aspects of recommendation 2? I don't think we had any pre-submitted comments. Anybody? None. Okay. Let's turn to recommendation 3. And Robert Stone, can I return to you here, since your comment really was keyed to recommendation 3? Let's pick up with your comment.
Okay. My concern really, when I originally read the text, struck me that this is a lot of material people are going to have to wade through, and most people probably won't need to do so. It's just a waste of resources. So we have a more flexible language which would allow people who are interested in it to access it. So I mean, a few words would just modify them. My thought was, I don't know which technology might apply, but my thought was after paragraph 2, you'd add a comma or a link to those notifications, comma, but it might be something other than a link. But that's the thing I'm suggesting. It's not a major change. It's just allow people to opt out to read all this material unless they really want to.
Emily, do you want to jump in on this point or on a different one?
It's a sort of broader. Let's run the course of what he's saying, and then I'll jump in.
Okay. I don't know if the ACUS team in drafting this, or Christopher, if you have any sort of thoughts on this problem of the disclosures getting sort of buried in the tidal wave of everything else that's in the agency materials. What's the right way to do this?
I would defer a lot to the expertise representing the committee. I think the idea of doing it in as a link is a possible one. My general sense is the boilerplate at the end of NPRMs I didn't regard as particularly onerous, but if people's experience is that making the NPRM longer in this way simply burdens people without providing any benefits, then I think it could easily be shortened by noting that the procedures are described in a link and doing it by cross-reference. The issue is more disclosure than anything else. Frankly, I think most people, unless they're really concerned about it, would essentially read mostly the substantive provisions and jump over that material, which means that including it would simply waste paper and burden the environment more than anything else, and that a link the reference would be a cross-reference through a web link would be suit the purpose, and the recommendation also is to include it in the pop-up as well, and so that as you see it, you understand what's going on to reinforce it. I do think it's not necessarily a certain amount of redundancy is important or is appropriate, just especially if it's a very low cost, just to reinforce to individual commenters the consequences of what they're about to do.
Now, as we can see in the comments on the document, Rebecca Orban noted in our previous discussion that this goes to both sometimes the agencies, sometimes the GSA, depending on the facility through which the comments are being submitted. I mean, I think in general, what this recommendation is trying to get at is disclosure both in the agency's call for comments and the notice of proposed rulemaking, but also at the point of commenting, right? Whether that's on regulations.gov or an agency-specific website. Do others have comments on this about the risk of either redundancy, the risk of not having the disclosure really visible to the public? Go ahead, Emily.
So I think there are several issues that we've talked about so far that maybe warrant separate treatment together, which is there are a few places where it seems like there are things that agencies could do by themselves, but maybe it would be more efficient and clearer to the public if they were done centrally, for example, by the rulemaking PMO or some party well situated to sort of offer these resources across agencies. Like having more boilerplate in every rulemaking document doesn't strike me as good a solution as having a standardized notification available on regulations.gov that agencies can maybe choose from a menu of options of what notification is appropriate in a particular rulemaking. But those are the kinds of things that agencies individually can't really do, that e-rulemaking PMO or whoever else it is at GSA maybe needs to do some of that. And this came up earlier, or a similar point came up earlier when Professor Yu was talking about how agencies would hopefully go to a vendor who would provide the right technological tools for agencies to be able to do comment analysis or whatever. That's another thing that if the hope is that there's going to be a government-wide solution from a private vendor, then maybe we should have a recommendation to an appropriate centralized government entity that can do that. So I guess my ultimate question is, why don't we, or should we, have a recommendation, maybe a separate and new recommendation under its own heading that is a recommendation to the e-rulemaking PMO or to GSA to, in some manner, assist agencies in, doing all of the things that we're recommending that they do.
So anybody have any thoughts on this point? I'd be particularly interested, comments from anybody, but if anybody in the agencies have any insight on how this would play out in practice in their agency, that would be helpful. Well, I'm really not sure how to go forward on this one. If anybody on the ACUS team has any suggestions, it could be two separate recommendations. It could be subparts of three. We could say, in order to provide the public with the notifications described in paragraph 2, and then the first recommendation could be, to the extent we want it to be in the notice proposed rulemaking, maybe we don't, maybe it's too much boilerplate. Agencies should apprise the public of the possibility of disclosure of sensitive information in their rulemaking, but then separately 3B would be GSA, these other entities should notify the public of the possibility of disclosure of information at the point of commenting. I always feel bad when Todd tries to type down when I'm just spitballing here. Sorry about that, Todd.
Another possibility would be to have a separate recommendation, maybe at the end of the entire recommendation. It's the e-rulemaking PMO and GSA, or whoever the right entities are, should assist agencies in implementing this recommendation, by assisting them with what the suggestions in paragraphs, and then we could identify the paragraphs that involve these kinds of tasks. So that way you could have one general recommendation that kind of makes clear that we want the centralized authorities in government to assist with implementation and identify the precise subjects where we would hope that that kind of centralized action might be taken.
Anyone have any reactions to this? And Andy, are you talking to somebody off screen, or are you trying to jump in? Oh, I thought I saw you talking. Anybody? I'll go ahead, Andrew Emery.
GSA having taken over regulations.gov, their e-rulemaking office would be sort of best positioned to do something through regulations.gov to make some of these announcements and notices to the public at the point that they're actually submitting the comments. So that would, I think, be the most efficient place for this to happen. And I think it's a perfect recommendation.
Can Andy Simons be unmuted? He has a comment as well. Maybe I can do it. I can't. Todd, is there a way to get Andy's sound back on?
I don't know why he has now been disabled for speaking. Oh, yeah, he's indicated as having chat allowances. It might be something on his end. I'm not sure.
Andy, I promise we're not muting you here on purpose. I don't have a menu option here either. Could you disconnect and reconnect, and we'll give it another shot? Does anybody else have comments on Emily and Andrew Emery's comments? I mean, what's the better place for this recommendation? Is it to split it off and put it at the end, or is it to keep it close to this general agency, this recommendation to the agencies to disclose? All right, Neil, go ahead.
Well, I think two problems. One, the agency is the one that's going to have to act on the information, but I think that the docket places where you can put the warning before you submit the comment, or submit the results of your review to make sure you have no information in there that shouldn't be in there. And it's uniform for everybody. They do it at the same time. They get double checked maybe before they can submit the document, and then they've got it in the docket or not in the docket. But the agency is going to have to be involved about whether they take something out. But it works so fluently between the agency and GSA that there shouldn't be a problem. In fact, I think, my former agency, I think when the documents came in to the docket, agency employees at DOT reviewed the document for things like where the comment came from, the name of the individual, that sort of thing. Then it went back to be submitted in the docket. But that could happen even if all the information, all the searching was done through computers at GSA.
All right. Well, maybe this then. So pursuant to Emily Bremer's comment, we'll add a comment, a recommendation at the end. The current draft is on the screen right now as new recommendation 15. It'll need a new subheading, right? Because it doesn't really fit under describing material an agency is withheld. So we'll need a subheading, something like GSA and e-rulemaking PMO assistance to agencies. Todd, can you scroll back up to recommendation 3? Let's make sure we also see what we're taking out of that recommendation, so we don't wind up with redundancy between the two. Okay, so why don't we strike out my comment, strike out my original suggestion. Okay, an agency should include the notifications described in paragraph 2 or link to those notifications in at least the following places. I think 3B is what we're effectively replacing with this recommendation at the end for GSA and rulemaking PMO. So we would strike, well, no, because there's the agency's own comment submission form. And I'm worried about that slipping through the cracks too, that to the extent that agencies have their own rulemaking platform, I don't want that to fall out when we're just referring generally to regulation.gov. So what about this? Leaving 2A in place, or sorry, 3A in place, 3B would say, on the agency's own comment submission form, if that agency has one. And then there's the automatic emails, which I will return to, I think, in a moment. On any part of the agency's website that describes its rulemaking process within an, okay, so now recommendation 3 really is just focused on the agency specifically. GSA and the PMO are split off to the end of the recommendations. Is this still too much redundancy? Do we need to strike out any of these? Andy Simons, I see you've reconnected. Do you want to take another crack at the comment you're trying to offer before?
Yeah, I'm sorry. I obviously missed a lot of what happened. So I'm not exactly sure where we are. I was just going to follow up to Emily. You know, on the, I agree that it's not always helpful to have more boilerplate. I will say in our case, what we do is we do have a link to a more expansive explanation of, you know, what people need to do in terms of identifying material and how to submit material that might be confidential, and some of that covers some of these things. So we have a statement in there and sort of cautionary that, you know, people shouldn't be submitting confidential material to the open docket, but then a link to, you know, further instruction. So that is one way we've tried to navigate, you know, giving some notice in the FRN, but not too much boilerplate. And then the other thing I was going to say, we often offer people the opportunity to just send us directly, like there's a contact and email box. So it's not an automatic response from FDMS or something, or regs.gov, but we give people the opportunity to just email directly to the agency. And I'm not sure how that would be covered here, but that would be perhaps another wrinkle.
Let's take this in 2 steps. First, whether any of these remaining recommendations in 3 should be deleted, and then whether any should be added. So should any of the remaining recommendations in 3 be deleted? Anybody? Robert, are you trying to speak?
No.
Okay. Anybody put their hand up? Sorry if I missed you. Okay, so let's leave. I guess the sense is we'll leave the remaining recommendations in place. Are there any specific recommendations that ought to be added? Andy, did you want to translate any of your agency's experience into specific additional recommendations? Or anyone else? I mean, obviously,
Sorry,
this
I'm
is
having mute issues.
Go ahead,
I
Andy.
apologize. This has been a challenging tech issue for me. I think that, I think we're talking about A, B, and E. Is that where we are?
3. I mean, I'm saying in addition to the ones that are there now, that on the screen right now are 3A through E. Are there any additional recommendations that should be added? Knowing that this recommendation is just a floor, agencies can always build above it, but is there anything that we ought to recommend to all agencies?
I don't have anything on the top of my head.
Okay. Anybody else want to jump in on this? Neil, I see your microphone turned on.
Well, you know, I didn't jump in when you were talking about taking this, but I think the automatic email, I'm not sure what you add by saying your comment's been received, by putting in something that it's in the agency's hands. It may be in the docket by then. You've put it in the ANPRM. You've put it in on websites. I don't know what it adds to add to an email that simply says your comment's been received.
Yeah,
so you can take that out.
Yeah, I see this as sort of just the last warning to somebody that, you know, if they submitted something inadvertently or even on purpose, that they wish now they hadn't done, they take it off. You know, it's their last chance to take action. But I agree. I think if one is going to be removed, it would be this one. Does anybody have any? What's the case for keeping this in?
I actually think that it's a good chance to give people a full range of the procedures. It's actually, if someone's made inadvertent submissions, that's the time where they would want to know about that. If they, I mean, I've submitted comments where I'm so focused on the substance of the comments and I'm up against the deadline, I put something in. And then when I've gotten that back, it made me stop and think a couple times. It's just a nice disaster check. If it's just a link to review the procedures, I do think that it's not to throw everything in the boilerplate, but if the benefits are, if the cost is sufficiently low, it makes it easier to justify. If the benefits are sufficiently higher, I think it's also the case. It did often, the emails I've gotten are, one, I'm glad to get them because it confirms the receipt. And second is, it's often a time where you sort of reflect on what you did, particularly if you were rushing to submit a comment at the end. So I actually do think there's value in it.
I mean, we're always mindful of burdens on agencies and putting in too many mandates for them to comply with. On this one, if it's just a matter of adding one sentence to a boilerplate email, the cost of that seems pretty low. Are there any other affirmative reasons, or am I misunderstanding that, or are there good affirmative reasons for taking it out? Taking the recommendation out, I mean. Okay. Well, then maybe I guess I'll put it this way. Does anybody want to move the removal of recommendation 3C, recommending that agencies include a sentence about this in their comment receipt emails? Okay. All right. Well, we'll leave it in. If anybody has comments, obviously send them along after the fact. Why don't we move on to recommendation 4? Robert, this is another one that you keyed in your pre-submitted comments. This is confidential commercial information. Robert, do you have any thoughts on this as we proceed into the conversation?
Actually, I don't recall submitting something on recommendation 4, but maybe I did.
Oh, it's well, just you mentioned in passing at the beginning of your comment where you say the agency resources constraint. Well, the agency has the resources to comply with the recommendation. For example, in recommendation 4A, we say the agency has the resources to identify and withhold confidential commercial information. Do you think we've sort of done justice to this point with that phrase?
Oh, I'm sorry. Yes, I was referring to that. Yeah, no, I certainly supported it, and it did allow a balancing. I'm sorry, I was using it as an example. That was good. Sorry.
No, thank you very much. Does anybody else have comments on the draft recommendation 4 with these 4 subparts?
This is Andy Simons. I guess I had a question, and maybe we're unusual in how we deal with confidential business information and the like. We have regulations and different ways that we treat confidential business information, and some are statutory, some are from our media statutes, and have other constraints, trade secrets, things like that. So we tell people the onus is on them to identify that in the first instance. We don't go through generally and try and identify that for people. And then if people identify it, then we offer these kinds of assurances. So to me, it's a sequencing issue. Like, to the extent that people want to submit this stuff and they identify it, we offer assurances. I worry about just offering blanket assurances a lot for the same reason, the resources and even the ability. I mean, you're assuming we can identify for others what they think is confidential business information. Seems to me a little backwards. Seems to me that, and number 6 kind of gets to it a little bit, like you know, what people should do to and how to flag it and submit it. That to me seems like it's the first step, and then we would offer assurances. And again, for us, there are definitely procedures, and it depends a little bit on it can depend on the rulemaking under what statutes people are submitting information. So I'm just kind of curious how other agencies deal with this. If this is really within the realm of possibilities and realistic for agencies to offer.
So recommendations 5 through 7 are all premised upon sort of the point that's made in 4 about agencies choosing to offer assurances, right? So recommendation 4 sets up this set of sort of this balancing test to decide whether to offer assurance as a protection for disclosure of confidential commercial information, including the resource constraint. And then 5 through 7 all begin with agencies that choose to offer assurance as a protection, right? Or 7 has a variation on that. So if we sort of prioritize 5, 6, 7, the substantive protections, we are sort of moving past this premise of this, which is whether the agencies are going to choose to offer protections at all.
Well, this is Neil Eisner. I'm troubled by 4 because, first of all, it seems to be giving criteria for making the decision as to opposed to the process. I would delete 4, and 5 and 6 I would refer to the fact that the agency will offer protection if a case is made by the submitting party that it should be protected. And that's the way my experience was in hearing these things. These things would come in when the commenter had information but wanted protection for them. The agency has already said we will protect confidential business information. It's not supposed to be doing that. This is just the process for doing it.
I don't know if the ACUS team or Christopher have any thoughts on why this was included to begin with. So I want to make sure that we want to make sure that whatever sort of justified its inclusion in the first place isn't given short shrift.
I can wait. Oh, sorry, Christopher, do you want
to? You go ahead.
Well, it was included to respond in response to Argus Leader, which the main holding of which is that materials that agencies accord or materials for which an agency provides some assurance of protected treatment has to be protected. The agency has to honor its word. So the idea here is that the agency first has to make a decision as to whether it's going to offer some assurance of protection. Once it has made that decision, once it chooses to accord protected treatment for such material, then it has to implement safeguards to ensure that the material is in fact protected. So it basically all stems from Argus Leader.
I think we get to that when we get to recommendations 8, 9, 10 later on. What you will do if someone writes you about confidential business information. I think this is actually saying what you do to determine whether it is confidential. This is the substance, and that's not supposed to be in here. The process is in it. And all we have to say later on in this document is, if we receive a request for protection of confidential business information, we will do the following.
I actually am, I have a lot of sympathy for Neil's comment, and it reminds me of what Matt was saying earlier, saying that we should that avoid discussing about substance, more about process. A, B, C, and D are more substantive criteria about whether to include it and not process it. And there is an argument for not including that. That's similar to the comments that Matt made in the last meeting. I think that comment in 5 and 6, I think that doesn't apply to them. Those are more process oriented in the sense that deciding, how to inform people, also, policies to how they are identified to make those clear in advance, to me are process oriented. The concerns about substance really focus on 4. And I will also just highlight from the report, we did recommend that the agencies have no obligation to screen dockets for confidential business information where the commenter has not requested confidentiality. Waiver rules largely apply, and that it's too difficult to automate. And even taking into account Argus Leader, our core recommendation is that this is more about advance notice of people's opportunity to avail themselves of a process and clarifying what that is. It also bears in mind some agencies depend a lot on this ability, and it's important to preserve this channel. And it's taken into account complaints from some agencies that some submitters are potentially abusing this process, where they're requesting confidential protection to large amounts of material that aren't properly confidential, and requiring agencies to consider processes for pushing back on that. All of which provides good arguments for providing more notice to preserve the integrity of this process, to give agencies the information they need to proceed. But I do think that the concern about substantive criteria may apply to recommendation 4.
So Chris, would your recommendation for recommendation 4 be to eliminate recommendation 4?
That is a decision for the committee. There is an argument for it. And I think that, that it may require a little preambulatory modification to the opening of recommendation 5, but that would be about it.
Yeah, I mean, for what it's worth, everybody, that's my sense too, is that, recommendation 4 is in there for a reason, and it's the reason that Todd alluded to, but these are substantive concerns. And if there's a way that we can allude to this in the preamble, and just leave it at that, that might be the best course of action.
Yeah, I would support that.
Okay. Would anybody object to that? Okay. Well, let's give that a shot and return to it in the next meeting.
So to add, to be clear, we're going to delete. We've decided to delete 4 in its entirety and just replace it with some language in the preamble about Argus Leader. Okay.
Yep.
Also, I think Andrew Emery just put a comment in the.
Yeah, I'm going to get to that next. Just returning really briefly to the last one, recommendation 3. Andrew pointed out, and I think it's a very fair point, that in recommendation 3, where we say an agency should include the notifications described in paragraph 2 in at least the following places, that amounts to a pretty long disclosure. If what we're suggesting is include everything, I would say we should just say should include or refer to the notifications described in paragraph 2, at least with respect to recommendation 3C.
And it's also helped by the fact that 3 says you can just send a link.
Yeah. Oh yeah, I'm looking. That's right. I'm looking off of. I was looking down at my paper, not up at the screen. Yeah. No. Let's actually just leave it the way it was. I'm sorry. I got confused looking at my paper. So an agency should include the notifications described in paragraph 2 or a link to those notifications in at least the following places. Oh, Andrew, is that okay?
Yeah, I think that's right. And sort of playing off Emily's, I agree. Like, we don't need to add a whole lot more to the preamble, to the preamble. That was just how we deal it, and I think others would want to do that too. So I think that does cover the base there.
Okay. All right. So let's pick back up then on recommendations 5, 6, and 7, where we left off. And this is the procedural ones. Does anybody have any comments on recommendation 5 as it's prepared? No. 6.
So this is Andy again. I wonder what I guess I wonder a little bit about providing specific examples, and I'm looking at A in particular here, instructing submitters to write the word private or protected. So, I just know that may go crosswise. For instance, for us, we do have explanation of how people can do it, I don't think staying private on it would satisfy those. So I guess I would caution selecting certain examples of what people should do in terms of complying with agencies' decisions once they make them to afford protections as to what those processes are. And maybe it can be just more generic and a reference to agency procedures, or just complying with those procedures on how agencies how people should identify that material.
I mean, what do others think? On the one hand, I suppose we should be careful about picking magic words, right, and trying to foist them upon the agency. On the other hand, to the extent that on the other hand, to the extent that we're taking care to avoid substantive protections and focus on process, we do need to make sure that there's some meat in the process side of things. What do folks think about this? About eliminating the specific suggested terms, private or protected, and just saying instructing submitters to. I'm not sure what the right phrase would be, but
I would
stepping away from the specifics.
Clearly identified as confidential business information. I mean, maybe that's the most I think probably most agencies would if they see that's a universal term, perhaps. It's partly a question, but maybe a suggestion.
This is Neil Eisner. I had a suggestion for language on 8, 9, and 10, I think it was, to simplify this, and it might address the concerns we're talking about right now with as it is, or with additional words. But 8, 9, and I think 10 would be read as follows. If notified by submitters that they inadvertently included personal or confidential information, I got to read the screen here. Hold on a second while I enlarge it. Personal or confidential business information in their comments, agencies should act as promptly as possible to determine whether it warrants protection, and if so, protect it from publication. And then you could add at the end of that, or if already disclosed, remove it.
So does this go to recommendation 8 or 9?
It goes to both.
Okay.
And I think it also gets 10. Because 10, for some reason, I don't see it. There were some different language being used about how fast you had to work and all. And I think it's simpler if we simply say as promptly as possible.
So are you saying that we'd replace recommendations 8, 9, and 10 with this language? You're saying we'd insert the same sort of new phrase in each of 8, 9, and 10?
I think 8, 9, and 10 can be put together. And I think they might substitute for the concern we have about, I think it's 4, 5, and 6, 5 and 6. What are you going to do you say you will protect confidential information. You balance things off. If people make a case, they can get the request make a request to the agency. The agency is saying, if notified by submitters, and it's personal or confidential business information, and the agency will do it will review it to see if it meets its criteria. The criteria are determined in a separate process, separate ACUS recommendation. Now, here's how we'll protect confidential information. Here's how we'll protect personal information. And when you submit it to us, we will act as promptly as possible to take action, to decide what to do. Because that's all that 5 and 6 are doing, is they're saying what the process will be once you said in order to get protection for confidential business information, they're going to have to do X, or have X as a reason for doing it. And that's the substance. We're now talking about the process. The process is, once an agency receives a request, It will act promptly to determine whether its criteria were met.
I just want to be clear here. I think 5 and 6 refer to instructions for the agency, recommendations to the agencies for what they should do at the beginning of the process to notify the public of what's about to happen in terms of submitting comments. What they should do as they submit comments to help flag these issues. The later recommendations, currently 8, 9, and 10, are focused on what happens after the comment is submitted and the agency is presented with a request to take down something that was submitted, either submitted inadvertently by the commenter, or even in 10, maybe material that was submitted by somebody else that involves the protected information of this third party that's now seeking for it to be taken down. Todd, is that am I right in framing it up that way?
That's exactly right.
And
there's another part of the framing. Just
hold on. Oh, go ahead, Christopher. Go ahead.
5 and 6 are addressed to only to confidential commercial information.
Yeah.
8 is addressed only to personal information, and 10 is addressed to both.
Yeah.
So, and so just to be clear about how that's going, and in all 8 is also, it's the way the proposal of rewriting, which I think is actually pretty helpful. If notified by submitters, what happens? There's also an element of 8 that says they should disclose to submitters of the process of asking for something to be taken down, which isn't currently uniformly available in all the documents. So just saying, if you need to make this request, here's the contact information, should be someplace. And that's one thing I'm going to make sure, if we edit 8, it's if we decide that that's important, that should be kept. But the only thing I want to make sure is we keep the difference between what applies to confidential commercial information and personal information clear.
Yeah, I'm confused.
Yeah, I agree with that.
Sorry, who said I agree with that?
This is Andy Simon, so I was able to rejoin again. I do think there is a distinction between personal and commercial, and that's worth probably keeping. Is my reaction. I would agree with.
Neil, what were you going to say?
I'm sorry.
That's okay. Go ahead, Neil.
8 and 9 and 10 are not, well, 10, for example, says agencies should allow people to request that personal or confidential commercial information pertaining to themselves or a dependent. I thought that was referring to a third party who's objecting to a submission made by another person. It doesn't.
I think that is what 10 is intended to get at.
Okay, and I think that might warrant that being done separately, but it should be done under the same standards. That is, agencies should act as promptly as possible rather than the language that's in there right now. That's what I was trying to get at with the simpler proposal with respect to 8, 9, and 10. But I didn't see 8 and 9 being substantively different. Agencies shall give submitter, if noted by submitters under 8, they shall give alert relevant agency officials to any personal information they inadvertently included, et cetera, et cetera. 9 says agencies should, agencies that submitters should have identified inadvertently won't be publicly disclosed. And by the way, somebody said it was just limited to things that were already put in the docket. I didn't read that as saying that under 8 and 9. I saw it as being both.
And I do want to put a footnote here that we're going to get back to recommendations 5, 6, and 7. But since we're focused on 8, 9, and 10 right now, let's just keep this conversation going. Here's my understanding of why 8 and 9 are framed the way they are. And Todd or anybody else, correct me if I'm wrong. 8 is just intended to recommend to agencies that they create space in the process for somebody to flag that they've inadvertently submitted a comment with protected information. And then 9 is what to do when somebody who submitted a comment flags to the agency that yes, they have submitted information inadvertently. And then again, 10 is focused on, maybe 10 could be made clearer either in the heading or in the recommendation itself, that when somebody recognizes that another party has submitted a comment that contains your own protected information, that there needs to be a process for reviewing that claim and possibly scrubbing it out of the record. Todd, is that a fair way of putting it?
It is like 99% of that was correct. The only thing I would add is that for number 10, it isn't just giving third parties the opportunity, it's also giving the submitter an opportunity to notify the agency if they inadvertently submitted something and then it gets published. So they didn't realize it at the time of submission, but then they realize, oops, I didn't mean to submit that. When they see it published, 10 is also meant to encompass that situation.
And Adam, if I may,
yeah, go ahead, Christopher.
I think, some of the comments Niels makes, there's some language we could do better, instead of referring to people, it might be more than just, it may be other actors, and I think that we can clean up. The 8th recommendation is limited to personal information because with respect to first party submission of confidential business information, the law pretty much clearly indicates submitting it waives it. And so there is no opportunity to take that back. With respect to personal information, certain types of that, agencies remain under some legal requirements of non-disclosure that aren't entirely subject to waiver by the individual. And as a policy matter, most agencies believe that even if they're not under a legal obligation to do so, and if it is a waiver, it may be good policy to give certain people the opportunity to do so, because it's not a good idea to have a social security number sitting in a permanent record that's available on the web. And so that is what I think the structure of this is. I think the feedback here saying we may be able to refine this somewhat, but just to explain, there is a difference between waiver that for the first parties, confidential business information, once it's submitted, is out. For third parties, you cannot waive someone else's rights. And this goes to the comment Dick Pierce made about the federal rules last time. That's just not something that's permitted. And so that 10 exists to create a process for includes commercial information, because that could be disclosed in a way that could not be construed as a waiver if it's done by a third party.
Okay. Given everything that's been discussed, maybe the better way forward on this, especially since we have about a little less than 25 minutes left for today's meeting, would be for the ACUS team and Christopher and I to propose, based on Neil's comments, to propose specific new language to be discussed at the next meeting. Matt, is that a fair way of doing something like that in these meetings, to go back to the drawing board and try to return to it next time?
Sure.
Okay. Neil, would you object? Real quick, Neil, would that be okay with you for us to try this and bring it back to the next meeting?
Yes, that'd be fine.
Okay.
And I'd be glad to help with drafts.
Thank you very much. Andy Simons?
Yeah, just while we're on there, just as you're redrafting, one of the issues that sort of was flagged for us, and it comes up in 10, and I was going to raise this just more generally. So I think with PII, I agree, agencies are, pretty good at just, and we can take that out easier. I think CBI is a whole different ball game in determining, whether it is, and there's a whole process, and people probably already know this, but sometimes we allow people to just identify it, and then we review it, and there's a substantiation process, and that can be fairly lengthy, it can be fairly contentious. And so when it says, here agencies should review such requests and determine that it is in fact, CBI, they should take steps to remove it. I mean, that can be a pretty lengthy process, and it's and a complicated process, and so that was one of the reasons I was also thinking why it's good to keep those two things separate. But in terms of redrafting this, the affirmative duty on agencies to sort of go through and follow through on this in the context of a short period of time where comments are in the docket, just not sure how realistic that is.
All right. I do want to, before we move forward with any other recommendations on this, and like I said, we will go forward with that as it says in the document, as Todd's marking it up. We'll return to this next time, but in the meantime, we'll try to propose some new language. I want to get back to 5, 6, and 7 because there was one issue that was raised that we never resolved, which is at old recommendation 6A, instructing submitters to write the word private, protected, or other or similar language. I think it was it Andy Simons that raised that issue. I don't think anybody else has weighed in on that yet, and I invited comments. And I do want to close the loop on this, whether we want to amend that recommendation to take out the specific suggested words. People are shaking their head yes, but I'm not sure whether that means yes, leave it in, or yes, take it out. Dick, you were shaking your head yes. What do you think? And you're muted right now. Oh. There you go.
Well, I like the modified version that is on my screen, just generally saying instructing submitters to clearly identify the confidential commercial information, leaving out any of the specifics, and then agencies are going to vary in terms of how that gets done.
Now 6B says to flag the particular text. I think 6A was aimed at clearly identifying that the document contains confidential commercial information. And then in 6B saying, furthermore, please specify exactly what part of the document. I actually think it's good to have both of those requirements in there for the submitter, or both those flags for the submitter, so that they are both making it easier for the agency to know up front which documents are at issue, and then furthermore, what information within the document. So I see Todd's already updated it. Does anybody object to this text? Okay. Andy, does it? Andy, does?
That's
yeah,
very
go ahead.
I agree to keep. I would keep that in. In fact, I think in our process, we ask that people submit both a redacted version and that could be posted, and the full version, right? So I think that's worth keeping in for sure.
Okay, Christopher.
For what it's worth, this is very much in line with the agency practices we found in our surveys.
Okay. All right. So then, does anybody have any further comments on the revised recommendation 6 as it appears on the screen? Okay. All right. Thanks, everybody. What about 5 and 7? And then we'll move on to 11. Any further comments on 5 or 7? Okay. Well, then let's jump past 8, 9, and 10, which we've just discussed, and we get to comment 11 and so on screening comments for protected material and protecting such material from disclosure. We didn't have any sort of pre-submitted comments on this language. Does anybody have? And we only have 15 minutes left, so if we start the conversation and it goes on, don't worry, we'll pick up with it in the third meeting. But let's just start with 11. Does anybody have any comments on the process for screening these comments?
I mean, this is Andy Simons. If we're going to make a recommendation that agencies proactively spend resources screening for protected material, I mean, that's a pretty significant undertaking. I think we alluded to that earlier. Sometimes there's voluminous dockets, and they're submitted often very close to the end of the comment period. So to me, this is one that we want to say a lot more about. Should consider, given resource. This is a big undertaking, I would think, if that's what's intended.
Now, I'll just point out that, in moving out recommendation 4, which went to not this specifically, but offering assurances of protection, there we had sort of the 4-factor balancing test, which, did kind of flag the resource constraint, and that's now moving off into the preamble. So maybe we do need to insert some kind of cushion here at paragraph 11, the current recommendation 11, to recognize the resource constraint. Andy, do you want to propose any specific language on this?
I mean, I would say, certainly should consider, and then maybe given, resources and I don't know what else we usually put in there. Whether, it's possible for them to even do this. And then if they determine that it can be done, here's some thoughts about how to do it, I guess.
I'd ask the ACUS team, given that this is something that that ACUS bumps into, over and over again in these recommendations. Is there a good way to go about doing this? Steve, Sean, and Matt, and Todd?
Sure, yeah, I can lay it. I mean, as it's presently written, I mean, that's pretty heavily qualified compared. I mean, certainly, we have recommendations that they should consider, given resource constraints or given legal limitations or that sort of thing. But whether it is possible is probably watering it down more than is typical for past recommendations, but it's ultimately up to the committee sort of how much qualifying language they want to put in.
I'd just be a little bit more direct than Reeve, perhaps, as I usually am. This one's going to invite ridicule at the plenary session.
So the entire recommendation, or just the?
No, that phrase right there. But look, it's not my decision.
I'm not sure how to respond to that. Maybe let me try something. Go ahead. Who's that? Allison?
This is Allison. I think actually, building on what he just said, Matt just said that we should come up with something else for this now, because otherwise we're going to waste 10 minutes at the plenary with people talking about consider given resources, whether it's possible, can be done. Like, people love to go after that.
Allison says it more diplomatically and more accurately than I have.
So if I may make a suggestion, if you just take out the words, it is possible for agencies, and just it becomes agencies should consider, given resources, whether to screen comments for protected material.
Yeah.
I think that's better.
No, it's certainly helpful to have the collective experience of the plenary here. But I think that the point is this would be a big commitment, and I'm, to be honest, especially when it comes to CVI, it's not even, that's usually, a business to making a determination and then substantiating it. I don't know how agencies, sometimes we can do a pretty good job of that, but that's an affirmative duty that that is somewhat fraught, right?
We could always insert a footnote with a CF site to obscenity law and just say we know it when we see it. But assuming that's not the best way of going about it, I'm curious. We say given resources, but that's almost redundant here, right? We're saying agencies should consider whether to screen comments for protected material. Obviously the resource constraint is one constraint, but there are others, both for and against screening, right? But other constraints, other legal requirements. Emily? Emily, we can't hear you. Is it possible is there another mute?
I'm wondering if we could just make this easier by just saying if agencies are going to screen, they should do it this way. I feel like there's always kind of a background, a background norm that agencies are subject to resource constraints. I'm not sure that we gain much by saying that in connection with some recommendations and not others. And if the point of this is just to give advice to agencies when they're screening, then we don't have to address I think at all really the circumstances or, you know, some limited set of factors that might influence their decision of whether to do that.
I mean, if we start this, let me just say really quick, Christopher, if we start this comment by saying when screening comments or something to that effect, some people are going to say, well, that presumes that agencies do screen or should screen and so on. So we might wind up back in the same conversation. But I agree, there's got to be a short and sweet way to say this. Christopher? Christopher, you're muted.
The concern about cost was expressed with respect to confidential business information. It's obviously the committee's decision what to do, but the report actually does not recommend putting any obligations on the agency to screen for CBI. This is entirely about personal information, and that's backed by law because the legal obligations, basically under CBI, if the first party submits it, it's a waiver, and if a third party submits it, it's probably not a trade secret because secrecy and not being generally available is the fact that it's being submitted by someone else and known pretty much bursts that bubble. And so the obligation to screen on CBI is very, very weak if it's, in our opinion, well, based on law, not there. And so there are some lingering obligations on PII. One way to address the cost concerns possibly is to move this away from talking about protected material and focusing more narrowly on personal information, if that's what the committee decides, that's what the report recommends, and if that's what the committee decides is appropriate.
I have a question.
Go ahead, Neil.
Is 11 after it's been put in the docket? It just says if agencies are going to screen comments, or before it's put in the docket, because you're talking about once it's put in the docket, they've waived protection. But I was assuming this was before it was put in the docket.
Christopher?
This is for material that's been put in the docket.
Put in the docket, okay.
And just to reiterate, is there waiver for the protected personal information too, or there's just waiver for the confidential commercial information?
Again, there's some readings of law that says there are obligations that exist and that we don't have strict law on whether that constitutes waiver. And there's an argument that it's not. There's a separate policy consideration. Even apart from waiver, there are some pieces of personal information which should not probably live on the web, and as a matter of good policy should be screened out. And so even if there is, first, as a legal matter, there is a chance that this can't be waived. And second, although the law isn't fully developed here, second, even if it can formally be waived, there's an argument that for the other legal policy values of protecting certain types of information reflected in the Privacy Act, the E-Government Act, and all the other statutes we mentioned, that this would be a good policy decision. Bearing in mind the AI, most of these things about numbers, if assuming AI can do this quickly and easily, then that changes the balance in favor of being more proactive by the agencies.
Todd, let me propose some language here that might cover this. To the extent that agencies screen comments that have been submitted, comma, either as required by law or as a matter of agency discretion, comma, agencies should take into consideration the following, or agencies should consider, or consider the following factors. I'm not sure exactly how to put that, but that's how I would try to beg the, sidestep this question about what's required, what's a matter of agency discretion, without it implying anything one way or the other, and just say to the extent that agencies are doing this for one reason or another, they should consider the following.
And is there any reason not to say, because I find it confusing in light of the discussion and all these recommendations, after it's been put in the docket? So I think it'd be a very different process. That's how agencies normally get the request. Comes in with the document saying we need protection. Don't put it into the docket until you've reviewed it or something like that.
Well, let's be precise here. I don't want to misstate it. Christopher, Todd, or others, are we saying comments that have been submitted or comments that have been docketed?
So my understanding of this paragraph was that it's comments that were submitted, but that the screening, the recommendation was for agencies to perform the screening before they put comments in the public docket.
I agree. And again, we're talking about personal information here, not CBI.
So I was going to just add, maybe we can make that clearer. And maybe protected material is defined as just personal and not CBI, but when I just was reading it, I made the assumption it was more than just personal. So we said, comments containing personal identifying information have been submitted.
Okay, so let me try one more crack at this one then. Actually, you're kind of on a, Todd, can you scroll down a little bit to that language? Okay. Todd, can you scroll back up to the language so I can see it on the screen? On my screen, I'm just seeing like a page break. Thanks. Okay. To the extent that agencies screen submitted comments prior to docketing, comma, this is going to get a little messy.
For personally identifying.
Hold on a second. To the extent that agencies screen submitted comments prior to docketing, comma, to prevent disclosure of PPI, protected personal information, comma, and then get rid of that have been submitted. So either as required by law or as a matter of agency discretion. Then pick up, the agency should consider the following. This might be the last thing we have a chance to touch on. We'll pick up with the remainder in the next meeting. Does this sort of complex sentence cover what people are getting at? Christopher?
Can I make one minor suggestion? Instead of prior, because docketing can be ambiguous, because even if it's not published, it could be part of the docket. Submitted comments prior to publication in the public docket, I think is trying to get what you're getting at. Tell me if I'm wrong.
It's what I'm trying to get at, but I'm just trying to translate some of the concerns that have been raised. I mean, obviously, this sentence is not of Shakespearean quality, to say the least, and it probably needs to be tightened up. But I think we're trying to get into the beginning of this recommendation, these sort of caveats and concerns and specifications.
Two issues that I have. Does redaction refer to personal information? Usually you just get one piece of one word or one number that's taken out. So that's why I read this as applying to confidential business information. That's where you always have the issue. What do you delete? What can't you delete? What makes the document useless? The other problem is commenters submit something for publication in the public docket. You want to make sure that PPI doesn't go in. Don't you want to talk to them before you make a decision to redact it? Because they may not be concerned about saying, I have some disease that you're studying. I have cancer. It just says you will redact the material.
Maybe this will be the last comment we'll pick up in the next meeting. Christopher, what do you think about this? I mean, ironically, if we prescribe a procedure for the agency to follow up, we're going to run into the agency process constraint. I mean, here we have just sort of a categorical, sort of cut and dry, simple way, but maybe it's too simple. Christopher, what do you think?
So I think that there are some categories of information for which the inference is strong enough just to prohibit publication without checking with the person. Just because, based on laws, particularly the E-Government Act actually puts an affirmative requirement on judicial disclosure. There's language about rulemaking, which is a little bit more complex, but there are affirmative mandates about non-disclosure of public records of certain kinds of information. I do think that the comment is well taken, that there may be things. One example is a very personal narrative. I have such and such a disease, and this is what I learned from it, and this is what this change in laws would mean to me. The solution of checking with them does put another lap on the agency and awareness of the resources. It does create a burden there, and that is something that I think the committee members are better position to weigh than an academic consultant supporting a report.
Okay, so we're at noon, and I want to be respectful of everybody's time. How about this? Why don't we take the conversation so far, and the ACUS team and Christopher and I will try to translate this into new language. We'll pick up with this next time. In the next meeting, we're going to have a lot to do in terms of finishing up the recommendations, including the other one that we've bracketed for further conversation, and then get to the preamble. And so I'd ask this, and I hope I'm not putting too much of a burden on your own resource constraints. I'd really encourage people to take a look at the preamble, and to the extent possible, send any comments you might have so that we can get things on the table with the preamble discussion pretty quickly, so that we don't give short shrift to it, because we keep, I keep shoveling things into the preamble, and I want to make sure we actually do justice to the conversation of the preamble. So to the extent that people can comment on what's already in the draft preamble and send some comments over, either formally or informally, that would be helpful. Matt, Reeve, Sean, Todd, is that a fair way of doing it? I don't want to sort of break protocol or anything.
I think it all sounds good.
Okay.
Thank you, Adam.
All right, everybody. Well, thanks for your patience this morning. We've covered a lot of ground, and we have a lot of ground left to cover next time. The next meeting, unless I'm incorrect, is August 31st. Is that right?
Yes.
Todd? Okay. All right. Is Reeve, Matt, Todd, Sean, is there anything else we need to say before we jump off the line?
Not from my end, no. I think this all went very well, and I think that sounds like an excellent plan going forward.
Well, on that note, thanks, everybody. We'll see you in a couple of weeks. Bye.
Thank you. Thank you.
Thank you.
Thank you.